Right, so I'm basically just doing a. This is basically just a video about the Criminal Law Act 1967. Now, what has the Criminal Law Act 1967 got to do with all this? There's also the Public Order Act as well, 1985 or 6, that's where they pull the Tumultuous Petitioning Act. This is when the CPS are formed. That's kind of relevant, but 1967 is actually quite significant because they're doing things to do with our privileges and rights. Now, this is the Parliament book on Privileges Report 2013, right? I've made my own custom cover for it. This is like a BentCop.biz cover. You can actually buy this. Apparently it's £15. You probably buy it from the government stationery office. But I was thinking about getting my own version printed. The stationery office sell pretty much everything that you could buy. I mean, £15 isn't that expensive, actually. I was thinking of just getting my own printed up because I've got the PDF. I don't need to buy it. I've got it. I've actually got it. The PDF file. You can download it, so I've got it to read. But I kind of wanted a book. They sell the book, but I kind of wanted the BentCop.biz study version, just like customized, because the thing with this parliamentary privileges and so forth, they're not acknowledging errors in law. So what I've done is I've collected some pieces of evidence which help show that the legislation is in contradiction, incompatibility. And I've put some of the evidence from the acts on here just to make a point out of it in the actual privilege book, just like, because it's kind of just like a statement, basically. But I've also got the book from the Constitution Society. I mean, I don't need to buy this. I've actually got, it's free. It's free. You download it and you can just read it. But I kind of wouldn't have minded making my own physical copy. And when I have like a study copy, I kind of like to make it my own. I don't think that you can buy this one in the shops. I don't think that he might have his own version, but this was just in PDF format like that. Like the book from, like the other book that I've got, which is only PDF, and I printed my own up just for study. So anyway, but I'll put there's just a few things on here which basically, like, make a point out of, it can't be right. There's some error. Mainly, right, the Criminal Law Act 1967, in which they repeal here the Great Charter, Article 14, which is 25 Edward I, right? Now, you might think, well, what's the Great Charter? I thought it said Magna Carta there. It says the Great Charter. They repealed it, apparently, because it was unnecessary. But this is the thing. Now, usually, when they say the Great Charter, they mean the Charter of Liberties. The Charter of Liberties was always the Great Charter and the Charter of the Forests, right? But sometimes they call the Magna Carta the Great Charter. But then we've got this confirmation of the charters, which means that they're all official and confirmed and in law, which is 1297, which is when the Magna Carta is enacted. But the Magna Carta and the confirmation of charters all keep the Charter of Liberties and the Charter of the Forest in full and their entirety. Although they say that in 1297 there's some question if the Magna Carta is kept in full, but the confirmation of the charter says, and these the same. When it says, and these the same, it must be in itself, right? But the thing is, the Magna Carta does the same as the confirmation of the charters, which retains the Charter of Liberties and Charter of the Forest. So when it says, as these the same, does it mean that they are kept in their entireties as well the same? But what this video kind of really is about, These two books are both about parliamentary privileges. That's the subject of these books, right? They're about privileges of Parliament and actual government legislation. The Constitutional Society by Sir Malcolm Jack, who was the clerk in Parliament, right? He's head of the Constitution Society at the moment, right? Now, I'm just about to read this. I should have really... This was published in 2013, so it was kind of available when I started my campaign, but I hadn't really learned that much at that point, and I wouldn't have probably known how to find it back then. But there's been a lot of changes since then. We've updated... Well, there's been a lot of extra information, not changes, but information obtained from Brodie Waddell's team with the transcriptions of lots of petitions which are now available. And we had the Cambridge Press, which published Thomas Erskine May book in full without all the parliamentary edits. And that is like the guidebook from actual someone who served in Parliament. Funnily enough, around the time of the Great Fire and when the police were invented, and Sir Thomas Erskine May's there, and this character in one of the clerks in Parliament when they make one of the important acts of law for the clerks of Parliament. But what this video really, what I'd like to, what I want to, is it that one? This one. So this here, right, this is Schedule 3 of the Criminal Law Act 1967, right? I mean, this video really should be interesting to someone like Black Belt Barrister or even George Galloway or any of the campaign groups like Big Brother Watch or Resistance GB, that Graham Moore guy, William Keat, right? In this schedule of the Criminal Law Act 1967, and this act creates this assisting offenders. The assisting offenders is in Section 4. And that is all about if any citizen, any person is pursuing a criminal, if anyone obstructs them or aids the criminal, they're committing an offence. So that means we can go after criminals without being obstructed, not even by the police, right? And that's important because the Crown Prosecution Service, after they're formed in 1986, 85, 86, they've got a policy and an entire section in their website, which is their own rules, which they've created for what they call assisting offenders, which is named the same as in law, when the Criminal Law Act 1967, when anyone's pursuing criminals or trying to apprehend them, right? It's named the same, assisting offenders. And what the Crown Prosecution's entire section of assisting offenders is granting immunities to persons or offenders if they're going to help the police catch criminals, right? Or for witnesses. But the Chief Crown Prosecutor can approve it, or the Attorney General. But that's only them. That's through their own procedures and rules, right? And it's about basically like hue and cry. It's like hue and cry. We're officially going after criminals and you're helping us, right? So you're doing good work and we're not going to prosecute you, right? That's basically it. But they've got to get permissions because the police force and the CPS are an organisation that is rank and file under command. When you act as a citizen to apprehend a criminal, you aren't under anyone's orders unless you break the law and the police say they're going to arrest you. But that's the thing. When you're officially doing it, you're recognised. What the assisting offenders thing is on the CPS website, it's officially been recognised by the Attorney General. The Attorney General says, the Director of Public Prosecutions says so in writing. So no police officer can say you're not doing that, or no prosecutor can say you're not doing that, because the Attorney General's give you a sheet of paper in writing to say that you are doing that, and that's it. Doesn't mean that anyone can't use assisting offenders in law if that's what they're doing. If you're claiming it and invoking that legislation, you have the power to do that, but you just don't have a piece of paper from the Attorney General that tells every police officer or every prosecutor or every judge that you officially doing it for the CPS or police. But you can do it for yourself or for the people, right? That's like just a basic summary. Now, that's why the Act is important and why the assisting offenders is important. Now, this is why... So it has something to do with immunities, because the Crown Prosecution Service assisting offenders is all about immunities, right? Now, in this act, we've got repeals or obsolete or unnecessary enactments. And they're reckoning that 25 Edward I, the Great Charter, as they call it, Article 14, is no longer necessary. So they're saying they're repealing it. Well, what is that? Well, that's Magna Carta. It's not the confirmation of the charters, because they don't have 14 articles in the confirmation of the charters. There are not 14 articles in it. So it's not the confirmation of the charters. And the Charter of Liberties, I don't think actually has an official legislation for it, like the 1297 Magna Carta does and the 1297 confirmation of charters. And the Charter of Liberties and the Charter of the Forest, I think, are referred to through these acts. But I definitely think that they mean, I'm quite certain, if I'm wrong, but I'm certain that this, I've checked it up, 25 Edward I, the Great Charter, Article 14, I'm sure they mean Magna Carta. It cannot be the Charter of Liberties, because that has to be absolutely and totally retained in full without alteration or repeal, without question, through the confirmation of the charters. So it cannot mean the Charter of Liberties 1100. It cannot. So it must be in the Magna Carta. So they're reckoning then. So basically, I think they're trying to make out that the confirmation of the charters does not include Magna Carta. And they can change and alter and repeal Magna Carta. If you read the confirmation of the charters, it says, and these the same. Right? Well, the only two things... In 1297, they did two things, which you could refer to as these, which are the confirmation of the charters, 1297, and the Magna Carta, 1297, which makes it officially law. So that's these. I'm sure it means, and these the same. So the confirmation of the thing that says that it can't be revoked or repealed, and this the same. But if it's this the same, it means the confirmation. If it's these the same, it means the confirmation and the Magna Carta the same as the Liberty Charter and the Forest Charter, right? So this is really important here, because Article 14, as far as I checked up, and I looked into it when I did look into it, and I'm sure that I got the correct article. If I'm wrong, but I'm pretty sure this is like, there's a bit of uncertainty here, so you can correct me if I'm wrong, but if I'm right, taking into account that the confirmation of the charters doesn't have 14 articles, so it must mean the Magna Carta. That's the one for the Lords. That is the Lords' privileges, I'm sure. If I'm wrong, I'm wrong. If I'm wrong about that, I'm wrong about that. But when I checked up on it, and when I went through the different versions to see which exactly Article 14 is, because sometimes they're moving the numbers around and changing the paragraphs so that some parts are kept but given a different number, right? So, but I'm sure when I checked it, I'm sure that Article 14 is the Lords and Barons can be prosecuted or fined only by their equals, right? Which is a different and completely separate privilege to elected members of Parliament who are full-time working in a cause to a higher authority. Like a police officer's full-time job is working in a cause in a local commission, in a local constabulary, in a local area to the local courts, right? So it's almost like similar to a policeman, but not under the policeman's legislation, although an MP can use that if he wants to, because he does investigations as well, remember? Does whatever he needs to do. But so this cannot possibly... And another thing that I've been through in multiple videos is that... So this Article 14, if I'm right, is one of the ancient rights and privileges in Magna Carta. Now, they're still opening Parliament. I mean, I've been saying this for the last month or so, but they've been opening Parliament with a petition from the Speaker to the Lord Chancellor saying that they're invoking into effect all of the ancient rights and privileges, all of them, right, into effect, right? You can't invoke them into effect of use, right, if this has been repealed, okay? and then you're not invoking all of them. So that means that the privileges of the Lords are intact, because this cannot be repealed. So this is the major issue, right? But that also brings into question other things in Magna Carta, like the right for you not to have your horse and cart taken off you without your consent, no matter what, because it's your livelihood, and that goes on to driving licenses, right? That's important. And also in this Act, we've got the Tumultuous Petitioning Act 1661. Now, this is the Act about petitioning the King when we use immunities. When you are officially petitioning the King, right, for a matter to Parliament, Church, State and Law, this is when the citizens use their privileges, okay? So the citizens are using their privileges in the Tumultuous Petitioning Act 1661. That has got something to do with assisting offenders, right? It has, because it's using immunities, and that is the thing. So there are things in this Act which come under the same thing. And here it says changing the words at the court to quarter sessions. Well, I'm sure it was at quarter sessions anyway. I think this is also an error and mistake here from court to quarter session, because I think it was already at quarter session. So I think that they're lying there, but that's my own opinion, right? Now, what else is relevant or important about this 1967 Criminal Law Act and to do with immunities and privileges? Well, so that's just a little bit of a more of a close-up picture. Now, above here, this is all poetry. You can do your job and you can do your work in Parliament, and you can be a poet laureate. You can have panache. You can have style. You can do the work and make and change the law, and while you're doing it, you can have flair and show off and be a poet. And you can put certain in the listings. You've got creative, poetic license, right? Well, I would say that in this Criminal Law Act 1967, in Schedule 3 in the repeals, above the Tumultuous Petitioning Act, which gives us immunities when we're petitioning Parliament, right? And they haven't repealed it at this point, they're just changing it. Remember, you've got to get consent to go through the courts, remember, if it's over 20 people. Is this the Sale of Horses Act 1558, the whole Act, which is quite interesting. Why is that interesting? It's interesting for this reason, right? When it comes to driving licenses and them taking our driving license off us, thus our right to be able to drive and travel, in the Magna Carta, they can't do it without your own consent, even borrow them, right, or anything, right, or not even as a punishment. You can be fined and put in prison, but they can't take your cart and horses livelihood off you, because you need them to be able to earn money to pay fines, right? Now, the Sale of Horses Act is interesting because it says that they can't take or even buy your cart off you, right? Now, that has got something in common. It's got a recognition. It's got like a quirk, a commonality, a intellectual relationship to selling horses. Because in Magna Carta, you can't be forced to sell your horses, right? And that's important. And remember, this is the Act now, what we're looking at now, 1967 Criminal Law Act, which is reckoning that they're repealing some of Magna Carta. So they're reckoning that they can have it take your things off you without your consent. Like in some of the bailiffs are coming around and taking people's cars from them in Stop ULEZ. If they don't pay their fines, they're coming around and taking the car off them or the house. Well, under Magna Carta, they can fine you, right? But if you don't pay a court fine, you shouldn't really be able to take your car off you, right? And that's relevant even if you haven't committed a crime and they're sending someone around to fine you. So there's poetry in the Sale of Horses. But really, through Magna Carta, right, they can't really take your horse and cart off you even if you've been prosecuted or punished, because it's your livelihood to pay fines. You're meant to pay the money through working, right? So I think that Sale of Horses is put there as a poet laureate panache kind of thing, just to make a point, but for those who know. But this is my opinion, right? Also, in this Criminal Law Act 1967, it's got a piece on pardons. It mentions pardons, right? It says that nothing in this act shall affect Her Majesty's royal prerogative of mercy, but a pardon in respect of any offence, if granted by warrant under royal sign manual countersigned by the Secretary of State, shall be of like effect as a pardon under the Great Seal. Secretary of State. Well, what is relevant about this to add a note and reflect on? So, when the Attorney General or the Director of Public Prosecutions writes a authorisation under that assisting offenders, he is saying that effectively it's like a pardon. If you've committed an offence but you're going to help the police get criminals, it's pretty much similar to a pardon or the same, right? But from the Attorney General or Chief Crown Prosecutor, right? They're going to forgive you for your crime. You're going to help them, right? But also, under the Great Seal of England, by a royal prerogative and countersigned by the Lord Spiritual and Temporal, and signed by the King, right? Orange, right? They've given you license and warrant to not be prosecuted when you are petitioning the King, right? They've given you license in law, a warrant that if that is what you're doing, you effectively are pardoned for your crimes, offences. Although in the 1689 Claim of Right, the Scottish one, where you can't be imprisoned, it says that, you know, you're liable to civil action, right? Okay. So there's a relationship here. It covers the similar subjects. It covers immunities, because when you're seeking a pardon, you're seeking to be forgiven and not be prosecuted or even have it undone or appealed, right? But there is a relationship, that there is a similar effect going on here what needs to be recognised. And it needs to be recognised in this act, because this Criminal Law Act 1967 is all about, if you're doing good work going after criminals, then people can't obstruct you or get in the way or stop you from doing it. And also remember that, you're using powers similar to when you're petitioning, right? That there is a relationship between these things in this act, which is further evidence that this is an important act. Now, look at this part from this act here. Now, this is very important to the courts, because my judge, when I was in Leicester, right, this is really relevant, absolutely relevant to the whole issue, the whole complexity, the whole conundrum, the whole questions that arise. When people are talking about, well, it's not peaceful protesting, that when people are talking about these 1688 Bill of Rights, the right to bear arms for defence, the right to petition the King without being prosecuted, some judges and magistrates, are just like, this is ridiculous, preposterous, there's no such thing, right? And then they proceed, even though you might only be in there for like putting stickers up, if you start to say, oh, I've got immunities, I can't be prosecuted, they will come out with things like, well, what about murder? You can't just go kill people and be immune and prosecuted. Well, firstly, if you're not in there for murder and you haven't murdered anyone, then it's absolutely got nothing to do with it whatsoever, right? That's for starts. And if a judge or magistrate starts talking about something like that when you're charged with, dropping a paperclip, then he is actually going off subject to something that's completely and totally irrelevant. And they do this themselves. If you're in a court and you've stolen a loaf of bread and then you start explaining to the judge that, well, what happens if I'm in Scotland or climbing a cliff? He'll say, sorry, but this has got absolutely nothing to do with this case and I don't want to hear anything more about it, right? He'll tell you to shut up because it's not relevant, right? But yeah, when you're in a court and if you dropped a paperclip on the floor and you're talking about immunities from being prosecuted, then when the judge starts talking about murders, he's got absolutely fuck all to do with the murder. You haven't murdered anyone. You're not even for murder. It's got absolutely nothing to fucking do with it. Why is he bringing that up as a subject, right, when you're saying that I've got immunities? What you're actually doing is you're actually talking, He's trying to get you to prove the entire, full, complete, justify why the existence of immunity would be. You're not there for that. You're not there for that. You're there to say that, either you are or are not doing this, like with Lord Hanningfield. Either you're covered by the privilege or you're not, right? You don't dispute what you are doing or whatever if you're covered by the privilege. Now, the thing is that what it would have been useful to say to Judge DJ Watson in Leicester in 2019 in the summer, right, when he sat in court screaming at me across the courtroom saying that I'm delusional, right? Whoa, what about murders, right? Well, I would say to him, Your Honour, in respect to privileges and in respect to immunities in the law, you will find that the Criminal Law Act 1967 is all about this area of inquiry. And it's even got in Schedule 2 supplementary amendments. We know this Act is about immunities and protections because it's got assisting offenders, and that is what the Crown Prosecution are talking about when they use the term assisting offenders, right? There is a direct relationship between assisting offenders CPS and assisting offenders in the Criminal Law Act 1967, right? Through basis, right? And also the 1967 Criminal Law Act is focusing on privileges of lords as well, because they're repealing them, right, or claiming they are when they can't. And the Tumultuous Petitioning Act in there is cited. It's a very obscure act and it's very rarely mentioned or known about, but it's if you're looking for it in law, it's in the Criminal Law Act 1967. It's mentioned and claimed to be modified in a couple of word changes, which I don't think that's right, because they're changing the word from to what it is. They're saying they're changing it from something to something, but they actually change it to what it is from what it was. But there is no change, so it's basically effective. I think it's tosh. In my opinion, I just think it's tosh. But the Tumultuous Petitioning Act is about immunities of people who are petitioning, if it's under 20 people, unless they get consent from a court, right? So if there is immunities, if there is right to petition, right, then some people might be concerned about these murders and deaths, right? Which is what DJ Watson was concerned about in Leicester in 2019 when I was in front of him, right? But we know this. We know this. We know, panic. We're giving out immunities. What happens if someone murders someone? Well, they know all about that. They're not retarded. They aren't retarded. They aren't stupid. They haven't considered these things, even though they're making mistakes themselves. But they know all this. Now, in Schedule 2, in these amendments, they're talking all about this here, right? You see, look, from the words from murder to be stolen, there shall be substituted the words an arrestable offence for the words any of the said offences. There shall be substituted the words that offence. So in the Criminal Law Act 1826, which enables assizes, courts, and as extended by Section 8 of the Criminal Justice Administration Act 1851, courts of quarter sessions to award compensation to those active in apprehending persons charged with murder and certain offences. So they can award compensation. Courts of quarter sessions to award compensation to those active in apprehending persons charged with murder. So that they're helping police. This is 1851. This is around the time they took the juries out of the courts, right? So this is like hue and cry, right? This is people in hue and cry, right, who are going after criminals. So let's say, let's say someone gets killed or murdered and the police are trying to get everyone to go after them, and you're at work in a factory and then you have to help the police. You're all chasing after a murderer, right? Then you're out of work, aren't you? So compensation, or you might break something, or you might get damaged or hurt, right? So this is, that's like assisting offenders under the CPS, right? There's no doubt about it, that it's situational, right? But it's also like the right to petition if you're following a just cause, being protected. But this is saying you get compensation, right? I could do with looking at the Criminal Law Act 1826, But this is when they were still had the assizes and so forth. But this is why they would be messing around with the quarter sessions and assizes to do with the Tumultuous Petitioning Act. But, they're saying change the court to quarter session, but, there wasn't... it doesn't say the change assizes. There's only quarter sessions and assizes in there, unless it means they're changing the hundreds court, which is the divisional court. They could be changing the divisional, but it doesn't say they're changing the divisional court. It doesn't say changing the word divisional court. And it doesn't say changing the word assizes, and it says quarter sessions. But anything which... in that act, the word court is never used alone. It's either the court of quarter sessions, the hundreds court, or the assizes, right? So anything that was already quarter sessions, you can't change it to quarter sessions because it's already at quarter sessions, right? And it doesn't say change the words assizes, it just says court. They're not changing all of the courts to quarter session, because then they would be removing the assizes from it, and I don't think they're doing that. They're not doing that. And unless they're making it so you can't go to a divisional court, you have to go to the assizes or quarter sessions, right? That could be right, but it doesn't say that though. It says the word court, but I'll show you that in a minute. But anyway, so the word superior criminal court of County Palatine or court of great sessions, because remember that a grand jury, you can get permission from a grand jury besides, as well as 3 justices, or you can a mayor. There shall be substituted the words or quarter sessions, and accordingly there shall be omitted the words from and where any person shall appear to any court of sessions of the peace. Well, that would be 100 divisional court, wouldn't it? To other courts hereby mentioned. So they're aware of, murders or people being killed, right? Here, look, murder. And that is when you're actually using hue and cry powers. And hue and cry powers, if the police are telling you to help them, the police are officially asking for help, and you are actually officially helping them. And you aren't getting it signed off by Attorney General or Director of Public Prosecutions, right? But notice that you haven't killed anyone, but this is like if you're just pursuing or apprehending. It's not saying that anyone's got immunity from murder, but it's saying that, you got immunity as if you're going after someone who's killed someone, right? But it's still kind of like, it's all modelling. It's all framework. This is what skeleton arguments are all about. It's all around the same area of skeletal argument, right? It's all around the similar area of law and niches of law, depending on what particular situation you're talking about. I'm going to look at this Criminal Law Act. I didn't actually know about the 1826 one. Could do with looking at that. That Criminal Law Act 1826. So we've got the pardons in there, right? You already really what the right to petition is, 1688 Bill of Rights. You're already pardoned because you're pursuing a good cause, right? But as for murdering and killing people, well, the thing is, depending on what it is it a risk of harm or danger to persons or other people, right? That's already covered in the Criminal Damage Act, right? And you can have privileges for that. You're given exemption from privileges if you're putting people at danger or risk of harm. That's like a fire engine flying around the corner full speed. Somebody might die or get killed, but they're not intending to do it. It's not like murder, manslaughter, or poisoning someone, is it? It's they're doing their duty and someone accidentally got killed, which is relevant if you're all going after a criminal and you all have to run out of a factory and you're chasing after a murderer and something could or might happen, but they all might end up... What happens if someone kills someone and they all go after him and they're all grabbing him and they end up killing him, right? When they're just trying to apprehend him. He might die while... People have died in police custody, right? People have died in police custody. How about that in America, that black guy that got killed by that cop when strangling him? You see, that's similar sort of thing. But that's police. Magna Carta... I was just trying to check 1297, 25 Edward I CC. So this was I was just trying to clarify here if it was the Great. They're using the word the Great Charter, and if it's you see, you've got this word Magna Carta 1297, right? But it's the same 25 Edward I. If it's the confirmation of the charters, it doesn't have 14 articles in it. This is the confirmation of the charters 1297, also 25 Edward I CC, right? That's not the Great Charter, the confirmation of the charters, but the confirmation of the charters keeps the Great Charter. It hasn't got 14 articles in it though, so it cannot possibly be that. Can't be that. What was it saying? So in Tumultuary it says, yeah, in section 1, the words from at the court to quarter sessions. At the court. I don't think that there are the words at the court in it, because it says that a grand jury or a justice at the assizes or quarter sessions, right? But at the court, at which court? Are they changing the assizes to quarter sessions? If it's already quarter sessions, right, it ain't going to change to quarter sessions, I can tell you that. If it's at assizes, right, it's not saying it. It doesn't say assizes. What about at the 100? Right, at the 100. Doesn't say divisional court, does it? Doesn't say at the division. This is at the words divisional, right? So I don't really. I think that there's something odd about this. There's something peculiar about this. It doesn't seem to fit right. There seems some kind of error, and that this is the thing with the Great Charter. It's they're calling it the Great Charter, right? In law, it's actually called Magna Carta 1297, right? That's what it's cited as on the government website. So, this is the argument for its repeal. This is just, we've done that thing about the horses. And remember, in Magna Carta, it says that they can't take your car off you, which is equivalent to your car now, as a punishment. I don't even think they can do it if you don't pay the fine. But Sadiq Khan, the Mayor of London, is forcing people's vehicles off them. He's taking their things off them and forcing them to get the things that he wants them to have, not the things that they've got, right? And that's to do with the ULEZ fines, which I think they're taking people's things off them. The Great Charter, Article 14. This is a fake park. This is just someone sent me a link to a government pay a parking fine, and it's just a fake website. It's not even the government. It's invalid. But, the fines are invalid that they're giving out now. Confirmation of the Charter is 1297. Well, that's not the Great Charter, even though it is 25 Edward I still, because it hasn't got 14 articles in it. It's short. So they definitely meant the Magna Carta, because I don't think the Charter of Liberties it's mentioned for what it is. Criminal Law Act 1967. Oh, right. So this is to do with the Criminal Law Act 1967 has a lot of things to do with immunities and protections and pardons and pursuing criminals and being protected while you're doing it, or even getting compensation, right? It does have a lot of things to do with that. And the Crown Prosecution's own process, right, on their assisting offenders, which I've said. Now here, this is another Poet Laureate little bit, right? Section 14. Civil rights in respect of maintenance and championing. Well, what civil rights? This is in 1967, before all this Human Rights Convention, the Human Rights Act, these articles of, freedom of expression, freedom of speech, which you get all the time anyway, right? It's saying, right, this is with champity, which is like using criminal proceedings or law to get some kind of benefit out of it when you don't really have any interest in the case itself, right? You won't be petitioning. If you think about it, my own intuition about it is that, like, if you were to use privileges, right, to say that you're protected when you don't really have an interest in the cause, right? So it doesn't necessarily have to be money or possessions. If Extinction Rebellion, right, are campaigning against the environment, right, and you don't really have any interest in the environment, right, but you say that you petitioning with them just for the benefit of the privileges, right, it means that you're getting privileges out of saying that you're helping the cause when you're not really that bothered about the outcome of the cause, right? This is like Tommy Robinson, you know, if there's loads of people kicking off in the street, right, in the town centre, and there's a campaign group there, and if they say they've got privileges, right, and they're wanting to save dolphins, right, and then a load of Tommy Robinson hooligans come up, and they're all kicking off, and then some of them say, oh, you know, we're saving the dolphins with these people, but they don't have any interest in saving dolphins. They don't care about dolphins, but they get the benefit of, they say they're helping the campaigners and get the benefit of the privileges of that case and cause without having a care or interest in it or outcome, which means that they don't really support the cause. That's my definition of it, which is different to what they say. Theirs is more like, oh, I'm funding a case, like, you know, you might be giving money to someone so they can sue someone, and you might not really be bothered about, you know. So, say that a couple's divorcing, right? So, and the company that the man owns is going to split between him and his wife, and let's say that you don't even care about it. You're not interested, right? You don't care whether he splits up with his wife or not, right? But if he proves that he does, right, then, you know, if you give money, you might make some money out of it. Also, there's a lot of these funding pools that will fund litigation. You know, you'll borrow some money off them to do litigation, and they'll get a return, they get their money back or whatever, or you'll give them some money. That is the area of law, how they kind of sort of mean it, to do with the financial part of it. But the way I see it is, I still think that it's still shampity if you pretend to have an interest in a case and somehow benefit from it when you don't have an interest in it. It doesn't have to be money or the money put up for to pay for it. It could be immunities. And this is when you've got like all those merchants and so forth. You know, there was a lot of merchants and enterprises that were getting immunities when they were out at sea from other boats, and, you know, they might have broke the law at sea, but they got protection from the king and so forth, you know, but they might not have been, you know, bothered about setting up a new plantation in Virginia. They might have just ended up doing piracy and, you know, taking people's, they might have ended up, you know, stealing things from other boats and ships, and using immunities or whatever, if they'd been granted them, if they'd been on paper or something like that. But they weren't actually really going after setting up plantation in Virginia, just doing piracy. I mean, that could be another example. There are many different examples, but so it does kind of involve it can involve civil rights. Well, this is the thing. Also, you've got there are witness immunities as well. You know, that there are also witness immunities as well. But it is talking about civil rights in respect of maintenance and championship. But so we'll read out what it actually does say, not what my opinion is. It says, no person, no one, nobody, under the law of England and Wales, right, they won't be liable for tort, which is civil, right? They won't be liable, no one is liable for civil or any conduct on account of its being maintenance or championship as known to the common law, right? They won't be liable for civil action for their behaviour or conduct under the common law, except in the case of a cause of action accruing before this section has effect. Well, there's something novel about that. There's something interesting and relevant about that you can recognise in that writing that also is noteworthy to mention, which is that if you have a case or cause which arises, like, someone robs a bank, or you want to pursue a grievance, right, a legitimate cause, if that arises before, right, that your anything, right, then you are protected from common law, but only for criminal, but not for civil liability. This is what it says in the 1689 Claim of Right. It says that, you're protected from criminal liability and imprisonment, but not from tort, which is like Extinction Rebellion really shouldn't be being prosecuted for any crimes, criminal damage, etc., but they should be liable under civil action, except for all their advertisements really are meant to be protected, and their speech, how their speech affects people and so forth, freedom of speech and all their advertisements. But if they damage anyone's private property, they're really meant to be liable to tort, right? As long as they've got a cause that arose before it, and they were acting in pursuit of that cause, not making it up afterwards, not damaging something and then later saying, we did it for an Extinction Rebellion advert when they didn't. I'm not saying that this is what this says, but what I'm saying is that it's ironic that the model and skeleton framework of it is similar, and they've called it civil rights in respect of maintenance and championship, right? And then we've got this. The second part is abolition of criminal and civil liability. Well, this is the thing. We're talking about criminal and civil liability. With the right to petition, we're talking about criminal and civil liability, or criminal not having criminal liability, right? But what it says is the abolition of criminal and civil liability under the law of England and Wales for maintenance and championship shall not affect any rule of law as to the cases in which a contract is to be treated as contrary to public policy or otherwise illegal. Well, we have got a contract in the 1688 Bill of Rights, and we have got a public policy that if you're pursuing a legitimate cause, you are protected, right? And that is a protection from criminal liability, but not civil. Now, the interesting thing with this section, this civil rights in respect of maintenance and championship, they're claiming that they're repealing that Magna Carta, the Barons and Lords immunity in this act, if I'm right, in that Article 14. And they can't do that. But they're saying that it's not required or not needed. And I think they're saying that it's not required or not needed because they're saying that, well, they've got the Article 9 of the 1688 Bill of Rights, which is what Jeremy Johnson KC is going on about in his 6-page paper, parliamentary privilege, right? Exclusive cognizance, right? But that exclusive cognizance and parliamentary privilege is only really for members of Parliament on the Cabinet elected doing their work, or their staff, their servants, and us when we are legitimately doing a petition campaign. It isn't that Article 14. It isn't that Magna Carta, Barons and Lords immunity. That is different. They've got that because of their rank and title and who they are in the House of Lords. They don't have it because they're working for Parliament. And this is relevant to the Lord Hindfield case, which I think where Jeremy Johnson case, he's got his paper wrong. But when it comes to all this champity thing and so forth, it doesn't really matter if you are pursuing a cause or not, if you're a baron or lord, because if you've committed a crime and an offence, then you have to stand for that crime. The only thing is that you get prosecuted by the other barons and lords, which is now the Supreme Court, right? It doesn't really matter whether you are doing work for Parliament or not. So therefore, you wouldn't be using a case or a cause for this sort of champity you wouldn't be trying to pretend you wouldn't have any interest in a case, in a legal case, a civil or criminal case, over any championing or not, right? But someone who isn't a baron or lord, it would be more relevant to them, right? But it's using championing under civil rights. It's specifically referring to championing. If you type in championing, it will tell you it's about, having interest in profiting from cases that people don't truly have an interest in, or for the sake of, outcomes or whatever, right? In here, it's specifically linking it to its relevance in civil rights and in criminal liability and civil liability. That's what it's here, right here. And they're trying to make it a little bit kind of technical and complicated here. But the thing is, right, if you zoom out of the box, out of the bubble, and if you think, right, well, okay, this little bit of writing here, okay, they're saying something, but what is happening in this act at the moment? What is even going on here in this Criminal Law Act 1967? What's happening? Well, they're actually claiming that they're repealing Lords and Barons' rights from Magna Carta when they can't. And they've also got sections on assisting offenders and immunities if you're pursuing causes or cases when you're protected, and if you're getting, official recognition for that. It's all in and around that. But also, even mocking, taking, selling and buying horses when they can't take your cart off you and your livelihood. But the police are doing it all the time, not taking your driving license. So there's a lot. My own gut feeling on this is that there's a lot of mockery. There's a lot of fun making, a lot of poet laureate digs at the law and at people, even amongst themselves, maybe even the Lords and Barons. I don't really know how they got this through, to be honest. I don't really know how they got this through Parliament. It's like with this Andrew Jones MP thing and that seatbelt law, which can get complicated, but it's not that complicated. He's basing it on something that he can't do, effectively. He's making a 50-metre seatbelt law up when it's already been prescribed to delivery routes, which are prescribed by a boss, like a doctor prescribes medicine. Your boss prescribes a delivery route, and it's only licensed to go on a certain delivery route. Like a bus only has licenses to do certain routes and so forth, and things like that. That's to do with seatbelt law, but it's still an error. It's an example of, errors that are made or contradictions that are made. So this is, this can be, what they are meaning when they say championing. It's definitely, they're meaning it in relation to criminal and civil liabilities and civil rights, okay? They might mean it in respect to different things that I'm talking about, but I'm just saying that it's included in this act when really this act is about, a lot of it is about... it's got the pardon part in it as well, which also ties into it, when that act already gives you pardon. So, there were just things... I'm not really actually talking about this act specifically, other than it covers and it's playing around it's dancing around the similar themes and same themes as what we're concerned about when we're looking at our right to petition immunities, and that is clearly obvious when it's bringing the Tumultuous Petitioning Acts into it. In fact, really, we should type up championing. Now, what I'll do is I'll go on Google with my other phone and I'll just type in championing, because I know that Black Belt Barrister mentioned it, but people, they're reckoning that championing is a common law doctrine. Well, that common law is under in front of a jury, like Magna Carta, that prevents a frivolous litigation by prohibiting a third party from paying for a lawsuit in exchange for a share of the proceeds. So what does that mean? Stripped down, right, to the bare bones. It means that, right, another entity or group or body or person, right, under common law, right, other entities, bodies or people, right, are going to give something or give aid in some way, right, give some kind of aid in a legal process, right, in exchange for some benefits, right, some benefit out of it, right. So other parties, right, giving some kind of aid, some form of aid to a legal process in exchange for some benefit. Well, that would be like if you've got Save the Dolphins who claim that they're protected, right, and they've got immunities because they're advertising, Save the Dolphins, or going about maybe even getting evidence to save the dolphins, and another group comes along and they say, we'll do that, we'll help you with that, can we come under the immunity or protection, right? But they're not really interested in it. This stops them from doing it. And actually, it's just, I've just had a click now in my brain. Something's just clicked in my mind now. That is like really like the Tumultuous Petitioning Act, right? Because if you think about it, right, if you've got 20 people, right, who are legitimately doing a cause, then everyone... that is kind of a little bit like the Tumultuous Petitioning Act, really, because you can't get loads of people, right, coming in on it, on these campaign petition without consent through the courts, because they'll be getting the benefits of that cause, won't they? So like everyone could just say, "Oh, we're doing it," when they might not really be doing it. So they've got to get consent through the court under that 1661 Act. They had to get consent, right? But you got so that exactly would be, that really exactly is like what I said in the example. You got 20 people doing Save the Dolphins, and you get a load of football hooligans come along, and there's some kind of thing, and then, or even the dolphin people or whatever, and, this is the thing. So, notice that the extremely rare, hardly mentioned, obscure and peculiar petitioning act, Tumultuous Petitioning Act, which is rarely mentioned in law. Mainly that the Crown Prosecution Service don't seem to have ever fucking heard of it because it got abolished when they were formed, right? Is that is mentioned in this act. In this act, it is given a citation and it is raised into relevance in this act, right? And that model of the Tumultuous Petitioning Act fits this Champerty model. Because that is preventing other persons from having a benefit of those 20 petitioners, right? Unless they go to the court and prove that they've got legitimate, concern for that cause. It doesn't have to be monetary. It doesn't have to be like just like a civil case and someone giving money or so forth, right? But this is the thing. Litigation companies very rarely give money out. It's hard to do it. It's almost kind of like, these small claims. I've also just thought of another thing now that falls under this. Like when all these companies are doing like, no win, no fee, no win, no fee, no win, no fee. It's very, very easy, right? If you trip on a pavement, or if somebody, if you have an accident, right, they're all saying, "Oh yeah, we'll do it. No win, no fee, no win, no fee, just fill a form in." And what they're doing, this is frivolous. They're doing frivolous claims, right? If you tripped up over on a pavement, or if somebody knocked you or whatever, they're doing all these frivolous claims, right, like seatbelt, whiplash or whatever, and they're throwing the money at you. They're throwing it at you. They're going like, oh, we'll do it for you. We'll put up all the money. We'll do all the court case. We'll get you some money. You've fallen over and you hurt your arm. Oh, this is dangerous. We'll sue the council, right? And they're getting them loads and loads of money, claims, and then they're making a benefit out of it when it was frivolous, right? It's meant to stop other parties from doing that, a third party. So instead of stopping Champathy, what we've actually got is like an absolute burst of it. And they're coming to you and see if you want to claim, what can I do for you? What can I help you with, right? But notice, when we really need to get a serious claim, like we're having as rights withheld by the police, we're getting prosecuted and we're protected by the petitioning rights, and we need pro bono, no one will touch us. No, we're not doing it. We're not giving you the money. We're not putting the money up. Or if you've been illegally prosecuted by the police or whatever, you're ringing all these solicitors up. Oh no, we're not going to touch it. Oh, I need to get parliamentary privileges. Oh no, we're not going to touch it. So when you really need it and when you've really been put at damage, they don't want to put the money up. They don't want to say, oh, no win, no fee, even though if you've got a strong case. But when all these frivolous little things, like play dead, play dead, oh, my legs are, filiforming, they're getting thousands of compensation. This is scandalous. It's like the National Lottery, it's like gambling. Gambling wasn't good, and now everyone's gambling. They've got everyone doing it, when it's not necessarily meant to be a good thing. In the religious beliefs. So everything what they're not meant to do in law, they're doing it on overdrive, right? And all the things that we should be protected by, and all the things that we need them to do with utmost urgency, are not being done. In fact, it's being denied. I mean, even Andrew Bridge and the MP, no one would touch him. Although, I think that his claim was frivolous because they're meant to be covered both by privilege, and it should have been the Speaker who, sorted it out should have punished Hancock in some way. None of the solicitors would touch Andrew Bridgen, even in his own personal cases, So even if you're an MP, sometimes these solicitors can not bother with you. They make excuses up now and say, oh, we ain't got the capacity if they don't want to do it, or, they say, if you ring them up on the phone, oh, I'm in a meeting, he's in a meeting, yeah, right, but that's another example of that. That's just some more examples. So it fits into it. I can see now how that Tumultuous Petitioning Act fits into it. This is basically just... This is the list of the repeals. So we've got, the Statute of Westminster first, the Great Charter, Article 14, and then it always goes on. There's a lot more than this. This is just like the first page. I just wanted to include it so we can see the Tumultuous Petitioning Act on there as well. So this Criminal Law Act is actually quite an important key act when it comes to immunities and protections, even though it's not more obviously about that. If you look at the sections, it covers things that are relevant, that are significant when you look into that area of law, which is why the Crown Prosecution Service have got it themselves, right? And that's how it fits into the Tumultuous Petitioning Act and this whole kind of Champathy thing. And whether or not, has Magna Carta been repealed? Well, how can it be if they're still using it at the moment in Parliament? And that means that, our ancient rights and privileges that they can't take our car off us or force us to sell it when we need it for our livelihood. And this is the whole thing with the police taking your driving licence off you, your right to drive, and even sending bailiffs around to take the car or cart, which I think is illegal. And they're just wanting to force us to get all these tech cars with satellite nav and tracking because they want everything to be... The director of MI5 wants absolutely everything under surveillance, which is what Big Brother Watch are campaigning against, they're trying to force people's vehicles off them because they don't want them to have old-fashioned ones, even though they might really, really like it. And it's theirs, it's their thing, you know. And it's actually against the Magna Carta and the rights of the people. And they won't be able to work to earn money to pay the fines off in monetary value. And all those ULEZ fines are illegal and against Magna Carta anyway, against the ancient liberty of London, because you can't have your tolls in London. So it's one big massacre and mess. You know, Sadiq Khan, the whole government. And this Hormer, or Hermer even, I keep pronouncing it wrong, Hermer, the Attorney General, is going to be sorting it all out and getting people to obey the rule of law, which you'll have a hard job doing if the law is broken, in error, you know, defective. So that's pretty much what I just wanted to mention. And I need to go check up the Criminal Law Act 1826, which I had not noticed that in that act. I thought that might have been the first one, 67, but there was an 1826 one. I wonder if that mentions the Tumultuous Act or any privileges or anything. If it does, that will be very, very interesting. So I'll go look at that. But I've got to read this. I've got to find some time to read this book of Sir Malcolm Jacks now. But I wanted to mention how the Criminal Law Act 1967 is like a key thing. It's quite, it's almost like an important cog in it all, to do with it, and even one a cog that might even seize up and, you know, cause the whole thing to be highly questionable. So that's that.